Damn it, Janet, stop charging by the hour.
Hi everyone, this is Janet Kirshen-Siegel from Semantic Shenanigans, and today I've got a new extra for you, and it's all about how music and copyright have kind of collided with each other, because one of the things that we've noticed is that not only is it images and paintings and books and whatnot that are subject to copyright, but so is music. And music can be, one of the things about music is that it's got an extremely rigid structure because everybody agrees on the notes. So you've got an A flat, it's an A flat whether you live in Turkey or you live in Detroit. Now, when we look at these copyrights, one of the first ones, and probably the first one that really got a lot of press is George Harrison. George Harrison created the My Sweet Lord song. He wrote it, and the allegation was that he had plagiarized the old Chiffons song, He's So Fine. It was probably the first case of musical infringement that most people had heard of, certainly the first one I had ever heard of. It's called Bright Tunes Music versus Harris Songs Music. And according to the Music Copyright Infringement Resource, quote, the court made much of the fact that both songs have a distinctive, quote, grace note, end quote, in the same melodic motive. Harrison's use of this idiosyncratic musical device along the lines of the court's reasoning that implicated him. It was akin to copying a mistake. The opinion's footnote number 4 contains a motive with the grace note and elsewhere acknowledges that the recording and sheet music Harrison ultimately released to the song after an earlier recording by Billy Preston do not incorporate the supposedly telltale grace note, end quote. So essentially what had happened in that case is that there was this small little change in the notes, and that seemed to be something that could well identify the older song, and it seemed to have been copied in the newer one. Ringo, on the other hand, he said that he told Melody Maker, and I quote, George was very unlucky. There's no doubt that the tune is similar, but just how many songs have been written with other melodies in mind? George's version is much heavier than the Chiffons. He might have done it with the original in the back of his mind, but he's just very unlucky that someone wanted to make it a test case in court, end quote. And I think in a lot of ways, Ringo is right. One of the problems with popular music and popular culture is, and it's not really a problem, it's just the way that it is that it's all pervasive. So if you've ever gotten a song caught in your head, and I think pretty much everybody has, one of the things about popular music is that it's meant to be catchy, it's meant to be memorable, and it's meant to kind of sort of dig into your head, become an earworm, as it were. And because that happens, you might not even be thinking about something, but it's still sitting in the back of your mind. Consider all of the things that we remember from 20, 30, 40 years ago. Very often we might forget how to do factoring in algebra, but we remember what was the hit song at the time. And we may be able to sing it a cappella without any prompting. Let's look at a few other cases that have come across our desk. One of them was Beyonce was sued over her song Drunk in Love. She ended up in court, but it was not quite what you'd think. It was actually about the Rockefeller Records logo, because apparently she didn't have permission to use it. Whoops. However, Beyonce did prevail because all the parties agreed that an in-house logo designer basically had come up with the logo and not the plaintiff. And furthermore, the court felt that the plaintiff had waited too long to bring suit. So essentially, that suit ended up as being more of an example of a plaintiff trying to go after deep pockets than anything else. One thing you might be happy to hear, really happy, is that Happy Birthday is now in the public domain. I remember when I was a kid, if you wanted to sing Happy Birthday, there was of course you could sing it in your home, but you never heard it on television or in movies, or you might hear like the beginning few bars of it or so, but you really wouldn't hear the entire song. Furthermore, when I was a kid, I remember going to a pizza parlor and Happy Birthday was on the jukebox, so you could play the song for, it was probably a dime at the time. You would see, like on older television shows, people would sing "For He's a Jolly Good Fellow," for example. Even when a birthday is the centerpiece of a film, such as 16 Candles, they never sing this song. Happy Birthday held on to its copyright like a barnacle holds onto a ship's hull, but it all changed in 2015. According to NBC4 Washington, a Los Angeles federal judge ordered that the song, which was probably the most recognizable one in English language history, the most recognizable English language song, end up in the public domain free of charge. Because the song dated back to 1893, although it probably had copyright protection from 1935, the court's ruling basically said enough's enough, so you should expect to hear that song in films and television shows. Another bit of music hitting the legal field in the elections in 2016. Mike Huckabee, when he was still a candidate, used to come out to the song "Eye of the Tiger." You may remember Bill Clinton had Fleetwood Mac's "Don't Stop." However, when Ronald Reagan tried to use Bruce Springsteen's "Born in the USA," the boss said, "No way, you can't use it." Now Huckabee, he decided he wanted to use Survivor's "Eye of the Tiger," but according to Daily Kos, Huckabee and Rude Music ended up settling out of court, with Huckabee agreeing to pay $25,000. But it gets more interesting because apparently he paid half and then he just tried to palm off the rest of it as a campaign expense, which was kind of unethical. The Federal Elections Commission saw things differently because Huckabee was trying to say that he was using the song at a religious rally because it was played during the freeing of clerk Kim Davis. You remember Kim Davis? She was the gal who said she wasn't going to issue any marriage licenses for same-sex marriages. Anyway, the Federal Elections Commission said, this is not a prayer rally. It's not a campaign expense. You pay this stuff out of your own pocket. By the way, this was not Mr. Huckabee's first time in IP infringement hot water. Evidently, in 2008, Tom Scholz of the band Boston, yay Boston, he publicly requested that Huckabee stop allowing the song "More Than a Feeling" be played at his rallies. We've got more. Lenz versus Universal Music Group. It seems innocent, but in February of 2007, Stephanie Lenz uploaded to YouTube a 29-second long clip of her then 13-month-old son. So her child is about 6 and a half or so by now, or 7, was dancing to the Prince song "Let's Go Crazy." You could only hear the song for about 20 seconds during this clip. It had very poor sound quality anyway. There was no way that you could possibly confuse this with the professional stuff that was coming out of Prince's studio, or that you would normally pay for. I mean, obviously it was a copy of it, but it wasn't like she was trying to completely do a sound-alike or anything like that. However, in June of 2007, so it was only a few months later, Prince's company sent a DMCA takedown notice. Yes, folks, it was for a toddler dancing to a fragment of a song in a video with such poor quality, there was no way anyone would ever confuse it with Prince's work. In June of 2007, so it's the same month, Lenz issued a counter notification and YouTube restored the video, so she fought back. Then in July, same year, so it's only 1 month later, she sues Universal for misrepresentation under the DMCA. And she also sought a declaratory judgment and to state that her work did not infringe. In September of that year, so now it's only a few months later, this one moved really fast. Prince released statements that he intended to, quote, reclaim his art on the internet, end quote. Then the following month, Universal released a statement that they would be taking down all user-generated content as a matter of principle. Yeah, whatever principle it was, but I think this was probably rather embarrassing. The courts agreed with Lenz. They said that Prince and Universal were issuing takedown notices as a matter of bad faith. Judge Fogel ruled that several of Universal's affirmative defenses would be rejected. That included the one that said that Lenz had not suffered any damages. While the courts felt that the damages she had suffered might not have been very big, the court still sided with her. In addition, the Ninth Circuit Court of Appeals affirmed the lower court's decision. They ruled that copyright holders such as Universal have, quote, a duty to consider in good faith and prior to sending a takedown notification whether allegedly infringing material constitutes fair use, end quote. So rather than accept the verdict, Universal ended up appealing to the U.S. Supreme Court. And with a shorthanded court, at this point in time, as of the recording of this particular post, the case is staying in petition. Now that the court is back on full strength, this petition might actually be heard. But this is going to be kind of interesting because, after all, the court might have other things to do with its time. Finally, let's look at the good old Stairway to Heaven case. In the Skidmore versus Zeppelin et al. Case, which was brought in the Central District of California, the Randy Craig Wolf Trust sued Led Zeppelin. Now, here are the facts. The trust claimed that Zeppelin had infringed on a spirit instrumental called Taurus when they were writing one of the most iconic rock songs of all time, Stairway to Heaven. Now, while Jimmy Page did admit that he owned a couple of Spirit albums, he also testified that he owned about 10,000 CDs and albums combined. So so we're talking about probably a few rooms worth of CDs and records. Now, both songs contain, and I wish I knew what this was because I don't, what's called a quote, a chromatically descending bass line under a static chord. That's sort of that very beginning part where you hear the it's just an acoustic guitar and you hear just a little bit of it, and it starts to go down in tone. But the thing of it is, lots of other songs have this kind of a tone, this sort of descending bass line. Apparently, that's a sort of musical cliche. Judge Gary Klausner, you remember that name from the Axanar case? Same guy. Klausner sent the case to the jury. They found no infringement. And at this point, as of the recording of this extra, the plaintiffs have appealed. So now, why did the trust wait so long, even after Wolf had died? And while he had complained a bit, but he never sued Page and Plant, although he had lots of chances to do so. So why did the trust wait so long? It's a good 40 plus years after this song was first released. What's the answer to this one? It's money, folks. There's really nothing else. Deep pockets. In any event, so music and the law, it's interesting. It's kind of fun to watch. It's rather different from looking at books and art, because you do need a bit of musical knowledge in order to really figure out whether something infringes and something copies or it doesn't. But just because musical notes by themselves certainly can't be copyrighted any more than individual letters can. Combinations, when they're put together, those certainly can be. Finally, for Semantic Shenanigans, this is Janet Gershon-Siegel. Thanks for listening to this extra. Bye-bye.
Music provided by Infocationary. Send mail to hosts@semanticshenanigans.com. Follow us on Twitter @2shenanigans. That's the number, not the word. 2shenanigans. On Facebook, you can find us at Semantic Shenanigans. Subscribe to our YouTube channel, Semantic Shenanigans. Thank you for joining us, and we'll see you next time right here on Semantic Shenanigans.